introduction? Well, I happen to have two. The first one is RS number 0702, and it is from the OSBC, and it deals with trust conversion. Any objection to that? Seeing none, that will be introduced. The second one is 0749, and it deals with bonding and securitization. Any objections to that? Seeing none, that will be introduced. Okay, the next item on our agenda is a hearing on Senate Bill 37. We'll open the hearing on that. Eileen, you want to give us an overview?
I will. Thank you, Mr. Chair, and good morning, committee. Senate Bill 37 amends KSA 2020 sub 40-4902, 40-4903, 40-4905, 40-4909, 40-4912, and 40-4915 of the Uniform Insurance Agents Licensing Act, and KSA 40-5505 and 40-5512 of the Public Adjusters Licensing Act. And the bill also amends KSA 40-241 pertaining to the examination of applicants for licensure as an agent. Section 1 amends KSA 40-241 pertaining to examination of individual applicants for agents' licenses. So under current law, if an individual fails to pass the licensure examination, the individual may retake the examination following a waiting period of not less than 7 days. So that would be their second try. If the applicant again fails the examination, the applicant may again retake the examination following another waiting period of not less than 7 days to take it for the third try. If the applicant again fails, the applicant may retake the examination after a waiting period of not less than 6 months for a fourth try. And again, if the applicant fails on the applicant's fourth try, the applicant must wait 2 years, and the examination and the waiting period cycle would reset itself, and the applicant would be able to retake a failed examination, and the cycle would begin again. The bill would strike that 6-month waiting period and the 2-year reset, and the applicant would be allowed to retake a failed examination after the waiting period of 7 days, relatively indefinitely until the applicant would pass. Section 2 amends KSA 2020 sub 40-4902, which is the definition section of the Uniform Insurance Agents Licensing Act. And here the substantive amendment was made to the definition of biennial due date to specify that it is the last day of the birth month of a licensed agent required to complete CECs, and the last day of the month of initial licensure for a registered business entity. Section 3 amends KSA 2020 sub 40-4903 pertaining to the insurance agent's license, renewal fees, and requirements. Here, new language has been added to the statute to require that an insurance agent pay a biennial renewal application fee of $4 and apply for renewal on a form prescribed by the commissioner. The number of CECs required for renewal has been changed. Current law requires a licensed insurance agent who is an individual and holds a property or casualty qualification or both, or a personal lines qualification to earn a minimum of 12 CECs and courses certified as property and casualty that include at least 1 hour in ethics. Current law also requires a licensed insurance agent who is an individual and holds a life, accident, and health or variable contracts qualification or any combination thereof to earn a minimum of 12 CECs in courses certified as life, accident, and health or variable contracts that include at least 1 hour of ethics. The bill would amend current law to require that on and after January 1, 2022, and with certain exceptions listed in paragraphs 3 through 6, each licensed insurance agent would be required to earn 18 CECs that include at least 3 hours of ethics and that may also include regulatory compliance. Section 4 amends KSA 2020 Sup 40-4905 pertaining to applications for resident insurance agent licensure. Amendments to this section relate to the disclosures made by licensed persons or entities to the Commissioner. On pages 13 through 14 of the bill, a number of items have been added relating to disciplinary actions on a licensee's license or criminal history, and the changes in information of the person or entity that the person or entity must report within 30 days of the occurrence. Section 5 amends KSA 2020 Sup 40-4909 pertaining to the Commissioner's power to deny an application or suspend, revoke, or refuse to renew a licensee's license if the Commissioner finds that the applicant or licensee has engaged in certain behaviors listed on page 16. The bill would add to the list a failure to respond to an inquiry from the Commissioner within 15 business days. The bill also adds a number of items that the Commissioner shall take into consideration when deciding whether to grant or renew a license, and those items are listed on page 16 as well. Section 6 amends KSA 2020 Sup 40-4912 pertaining to the appointment of agents. Under current law, certification of other than a licensed insurance agent will automatically include each licensed agent who is an officer, director, partner, or employee, or otherwise legally associated individual with the corporation, association, partnership, or other legal entity appointed by the company. Effective January 1, 2022, the bill would remove the requirement that these individuals or entities be certified and be required to pay the associated certification fee. Section 7 amends KSA 2020 Sup 40-4915 pertaining to the renewal of insurance agent licenses. The amendment to this statute allows the Commissioner to suspend the agent's license for 90 days if the agent does not apply for renewal by the agent's biennial due date, and the assessment of a $100 penalty for each license suspended. If the agent fails to apply for renewal after 90 days, but before 12 months are up, and the agent wishes to reinstate the license, the agent will be required to pay a reinstatement fee of $100 per license. If after 12 months have passed, the agent wishes to reinstate the license, the agent will be required to submit proof of CE completion and pay the reinstatement fee. Section 8 amends KSA 2020 Sup 40-5505 pertaining to public adjusters licenses. The amendment to the statute grants the Commissioner the authority to require the applicant for a public adjuster license be fingerprinted and submit to a state and national criminal history record check, or submit to a background check, or both, at the applicant's expense. Section 9 amends KSA 2020 Sup 40-5512 pertaining to continuing education credits for public adjusters licenses. And here amendments have been made to the definition of biennial due date and the CEC requirement to be consistent with the changes made to the Uniform Insurance Agents Licensing Act that I've described in the earlier sections. And with that, Mr. Chair, I can stand for questions.
Thank you, Eileen. Committee, are there questions of Eileen? Senator Pittman.
Thank you, Mr. Chair. Thank you, Eileen. That was a mouthful, I know, and a lot of work. I only had one question. It's on page 16 on line 14, section A. It says applicant's age at the time of the conduct. It seems a little odd to put that in statute, that we would evaluate. I was just wondering, is it common anywhere else in statute to actually have the age of the applicant be in consideration when talking about denying or revoking and suspending, because they've already got a license? There's no minimum age requirement that hasn't already been met. And is it to indicate that someone 18, 22, 44, 88?
It's not, I'm sorry, Mr. Chair, may I answer?
You may.
Would inherently have some kind of, would the age actually matter? It seems like it's putting ageism inside of the statute is what I'm saying. So maybe you could respond to that.
Sure, Senator Pittman. I don't, the conferee from the department can probably speak a little more closely, but I believe what we're trying to get at there with the language is if the applicant was, or if the licensee was 30 when the event occurred or the action occurred, and the agent is now 60 and renewing a license and is from a different state and has to disclose this information, the commissioner may take this into consideration and say, okay, the situation was so far in the past that it merits less consideration. I don't think it's the actual age. It's not age discrimination based, because I don't think that would be a legal consideration. I believe it's time frame based.
Thank you.
Additional comments or questions? Okay, seeing none, we will now turn our attention to the proponents. First up is Lee Modisette with the Kansas Insurance Department. Welcome, Lee.
Thank you, Mr. Chairman, members of the committee. Lee Modisette with the Kansas Insurance Department. I believe you have my written testimony. I would like to touch on just a couple of things here with my oral testimony. Senate Bill 37 is designed to improve efficiencies at the department and make the cost of doing business on the whole for industry easier in Kansas. We actually brought this bill last year to the legislature as the Model Licensing Act, which included 24 hours of CE, 3 of which must be ethics. For those on the committee that aren't familiar with the model licensing, the entire intent behind that some 30 years ago was industry wanted a uniform standard across the board because there's a compliance cost, in their office when they're trying to make sure that every agent is following all the different state rules and regs. And kind of the perspective was a lot of states had different ways of handling that, and a lot of those were, in the industry's view, a distinction without a difference. That's how we got to the Model Act. That's what we proposed a year ago. Vast majority of states have adopted that, but some of the feedback we received at the department was, hey, we shouldn't be like everybody else for the sake of being like everybody else. We totally understand that, so we went back to the drawing board with the folks who had expressed those concerns and said, how do we get there? What does this look like? And that's Senate Bill 37 in front of you. If I could describe this, I would say that, again, we're looking at this not from a one singular perspective, but from the industry-wide. There are 55% of agents in Kansas are dual licensed. So for those folks who have expressed concerns about CE, we've actually we're proposing to make a reduction to over half the agents in Kansas. There was a question I've received about why not lower that for everybody. Kansas, for our single line agent folks, is actually already the lowest in the country at 12. The second lowest is Missouri at 16, but Missouri does not distinguish between the lines of authority. It's 16 hours of total CE. And so from our perspective, we don't necessarily want to keep going backwards. Already being lowest in the country, didn't see a need to continue going lower. The benefits to coming to one license with one CE unit is that from a department standpoint, we get a number of efficiencies. We have to have our own database that we currently track because of the way we do licensing in Kansas, and then a product called NIPR is how the licenses in all the other states are handled. I think other proponents will kind of talk about what that means, again, from an agency standpoint or a compliance standpoint. The other piece of this, and without giving too much of a history, because I've spent a number of hours getting the information about this and why it's taken so long to get here. One of the reasons that previously there had been a number of opponents to the bill is that previous commissioners, when trying to do this, had looked at this, how do we make this revenue neutral? And to do that would require a significant increase in fees for our agents. And the reason for that is one of the elements of this bill is actually eliminating the automatic appointment of agents from agencies to carriers. So what that A good example would be if I'm an agent with an independent agency and there are 10 carriers that they write business for, those carriers have to appoint all of the agents in an agency by statute automatically. You may remember that it was a lawsuit a few years back related to the fee sweeps from our bank account. That was settled successfully by the department. But when we sat down to do this, we really looked at that and said, how much does the department actually need to function on a day-to-day basis? And the reality is that when this appointment was adopted in statute in the 80s, we didn't have what we have now in the marketplace, which is a number of call centers and the consumer's ability to buy insurance online. So we have anywhere from 130 to 150,000 agents from out of state, who are licensed in Kansas because of the kind of current direction we're headed as an industry as a whole. And so the big takeaways from the bill that the department wanted to really bring attention to is, in our view, this is, for those folks who are looking for licensure reform, this is licensure reform for over half of our agents. We understand that we are asking individual line agents to take more CE to get there for the majority. I've heard some of the comments, critiques, and definitely don't want to have the perspective of this is what we think the bill is. So I went and I asked NIPR, which has the data for all the other states. There are a lot of the questions have come from the health life side, so that's the data I had them pull. There are 1,058,000 health life only agents in the country. 19,000 of those, not including Kansas. Kansas has about 11,000. Of that, 19,000 are in Missouri, so they meet the 16-hour requirement, and the remainder of that, so 1,030,000, meet 20 or 24 hours of CE. So we understand that it is a lift that we are asking single-line folks to make, but when we look at this from our perspective, for the industry as a whole, we're looking at $5 million a year on an ongoing basis of revenue reduction to the department. That's obviously saving industry there. The efficiency that we get, the vast majority of our phone calls in our producer licensing division are related to, hey, I have 26 hours, but I don't have the 12 and 12, and so I don't understand. I've got my total number of hours, but I don't have them by line. That generates a lot of customer service on our end, and we're happy to do that. But it just seems like this is a better way on the whole for everybody, from a department and from an industry perspective. So with that, Mr. Chairman, I'd be happy to either take questions now or wait till after all the proponents are through.
Thank you. I think we'll get through the proponents and then we'll open it up for questions then.
Thank you.
Thank you. Next committee, we have Sue Ann Schultz with IMA Financial Group, and she is virtual. Suzanne, welcome to the committee.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to appear before you and testify in favor of Senate Bill 37. As noted, you have my written testimony, but I'd like to give you just a little bit of background. The IMA Financial Group is the 28th largest insurance broker in the United States with over 850 employees. Of those, 447 constitute my employee shareholder ownership base. We are an independent insurance broker, and we were formed in Wichita, Kansas, and that's our headquarters, and that's our state of domicile. We are exceedingly proud to be from Kansas, and we are exceedingly pleased to be able to testify in favor of this bill. You'll also note I have 329 employees in Kansas, and we have offices in Topeka, Wichita, Kansas City, Overland Park, Wellington, and Emporia. There are three primary substantive provisions in this bill, as you've heard from the Kansas Insurance Department. There are a lot of cleanup provisions, but overall, the bill clarifies the regulatory authority for the Kansas Insurance Department. It also allows them to use NIPER instead of having to actually submit your licensure applications, et cetera, through the department. It revises the continuing ed requirements from 12 hours biannually to 18, and it eliminates the requirement for carriers to appoint all licensed agents in an agency instead of just appointing the writing agents. We support all three material provisions of this bill. And let me just give you a couple of quick examples why. We deal with insurance departments all over the United States. I really appreciate the working relationship that we have with our Kansas Insurance Department. They are responsive, they are respectful, they look out for the consumer's rights, but they also care about the industry. The reason they care about the industry is they understand it's a partnership, that we have to have the insurance marketplace to protect our consumers in our state. In order to do that, we need efficient and effective regulation. And I can tell you, having dealt with an awful lot of those insurance departments, ours is one of the best. We appreciate their ability and willingness to look at continual efficiencies as represented by this bill. The ability to use NIPER, which we use in all of our other states, is far more efficient. It's uniform. You have the same information going into one repository that can be accessed by anyone who needs to look at licensure. So we very much support allowing that efficiency and that enhancement to their operations to move forward. There are only 2 or 3 states that don't use NIPER, and so this would be a standardization that would be very beneficial. Let's talk for a few minutes about the continuing education requirement increase. I've got 204 licensed agents in Kansas. We continually provide continuing education to our associates in-house. The insurance department is really excellent at allowing us to offer in-house education. They review the curricula, they approve it. Getting CE isn't a problem. As noted in my testimony, if you want to pick up all hours, you can do so for about $40. This isn't about the quality of education, it's about the professionalism that our industry needs to support. Our licensed agents are committed to continual education. They want to know as much as they possibly can about insurance because they're advising consumers about insurance. You all know yourselves, insurance is complicated. A year ago, nobody knew what COVID was. Nobody knew what business interruption was. Nobody knew what was covered or not covered. Today, all of us have been touched by that pandemic and by the insurance challenges that have been raised as a result. Continuing education is one way that professionals in our industry can keep themselves informed and provide that valuable insight to consumers to make the right decision for themselves, their families, and their businesses. So we strongly support this increase in the CE requirements. You can see from my own statistics, this is an increased cost for my company, but it's one we gladly will take on. Quite frankly, we don't have a problem with our single line insurance agents getting CE. They almost always have more CE than they need because they're dedicated to the principle of being educated and informed to be the best advisor for their clients that they can. Last thing I want to address very briefly is the appointment process. This is painful for our organization. As you can see, again, from my statistics, I have a lot of agents, but think about it. I've got over 1,000 carriers. Kansas is the only state that requires the carrier to appoint every single licensed agent in your agency in order to do business in our state. And the thing that is of most concern to me is we have a lot of challenging insurance placements. You've probably heard of it. We're in what you call a hard market. That means insurance is more expensive and it's more difficult to get, especially if you're in a business that the standard carriers don't want to write. Here's the issue with appointments. We are seeing it and we have experienced it. That will cause some carriers to simply say, I'm not going to do business in Kansas because I've got to go through all this paperwork and I have this added cost and it's an administrative nightmare to help you with 1 or 2 or 3 policies that you need to place. We want to and we need to encourage as many carriers to do business in our state as possible. That affords our consumers choice and gives them the best coverage and pricing options that are available. Making this change is one that we strongly support. We've been talking to the insurance department about it for years, and we could not be more appreciative of the fact that they're willing to be more efficient in their operations, forego that revenue, and as you'll see in my testimony, that's revenue that goes back to consumers and it goes back to industry. The Kansas Insurance Department is self-funded. That means we all pay their fees. And ultimately, it's going to come down to the cost of insurance and what a carrier adds onto their products to issue them in our state. So for all of these reasons, we appreciate the opportunity to appear before you and to testify in favor of Senate Bill 37. I stand for questions.
And thank you very much. We'll take questions after we get through one more proponent. And that is Elizabeth Smoller with the Kansas Association of Insurance Agents. Welcome, Elizabeth.
Thank you, Chairman. Try to get that down to my level. Chairman Longbine, members of the committee, thank you for the opportunity to talk today on Senate Bill 37. You have my written testimony. You've heard from Lee. You have heard from Sue Ann, so I will try not to take up too much of your valuable time this morning. But I also wanted to just hit on a few high points that moved our association to a position of support on this bill. For a little background, I'm with the Kansas Association of Insurance Agents. We represent over 300 independent insurance agencies across the state of Kansas, and those agencies employ over 2,200 agencies within their small businesses. We have worked with the insurance department on this bill for the past 2 years, and to be honest, continuing education has been a frequent topic from the insurance department probably for the last 20 years, I would guess. So for some of you that have been around a while, you have heard about continuing education previously. We spent much time with Lee and Commissioner Schmidt and the rest of the team at the insurance department, negotiated many of the provisions that are in here. The continuing education increase, definitely, it will be, in our opinion, the single thing that is felt most by agents. But as Lee touched on it, more than half of the agents in the state of Kansas already are dual licensed, meaning they have a life and health license and they have a P&C license. For those individuals, they will actually have to take less continuing education. It's only those agents who have just a P&C or just a life health license that will have to take additional continuing education credits, and it will be 6 additional hours every 2 years. So essentially 3 hours each year that they will need to spend, increasing hopefully their knowledge of the product they're selling and bettering what they do with Kansas consumers. We are supporting this bill by moving on those continuing education credits and making them general requirements. It allows the insurance department to use NIPR, as Sue Ann called it, the National Insurance Producer Registry. It's an online database that covers insurance departments across the state, but as an individual, it allows you to go in, answer all the questions for whatever state you have a license in, and then get your license, whether you're applying for a new one or, in the case of me, when you are renewing your license. So I have a birthday coming up later this spring. I needed to renew my insurance license in 3 states. For 2 of those states, I could go to NIPR and I just clicked the buttons, I answered the questions, I hit yes, and then 2 days later, my license was ready. I was not able to do that for Kansas. For Kansas, I have to log out of there, I have to log into a different system and do a completely different process. So obviously, not only from the insurance department, but from an agency standpoint, being able to use NIPR helps an agent save time. And yes, it's just a few clicks on the computer, but when you have large agencies and you're talking hundreds of people that you're overseeing their license compliance, this is a big time saving. It also, this bill creates a renewal process for agencies and agents. Right now, the insurance department does not have a way to track which agencies are still active in the state of Kansas. From a consumer standpoint, it'd be nice to know when you log into the insurance department and you put in the name of an agency to know that, yes, indeed, that information is correct. So it will help them clean up their records, make the information easier for Kansas consumers to understand. As I said, it abolishes that separate renewal for P in property and casualty and life and health and just makes it one seamless process. And then, again, taking away those automatic appointments saves money. Carriers that are passing down to agencies and agents, and hopefully gives us a more competitive marketplace in the Kansas insurance industry. And with that, I will save the rest of your time, and I will stand for questions along with everybody else.
Elizabeth, thank you very much.
Thank you.
Committee, I'll call your attention to written-only proponent testimony from Bob Shields with PIA, Scott Colby with the National Association of Financial Advisors of Kansas, and Bill Sneed representing State Farm. Okay, we will now open it up for questions. Senator Hildebrand.
Thank you, Mr. Chairman, and my question is for Lee, Insurance Department. Lee, probably more of a curious question. On page 20, where it talks about a public adjuster license to be fingerprinted, what is the current process right now?
That's a good question, Senator. I don't know, outside of the application, I don't know the current process beyond the application, what that actually looks like. I can tell you that the intent here, or the addition of this, is a few years back, there was an adoption of fingerprinting for new insurance applicants. And from the department's perspective, this was an oversight of adding these folks in as part of that process. So it's asking the public adjusters to do the same thing that new agent applicants do.
So they currently don't have to be fingerprinted now. This would require.
Correct.
Okay, thank you.
Additional comments or questions? Senator Gossage.
Thank you, Mr. Chair. First of all, the proponents of this are people whose agents are primarily dual agents, correct?
I would have to let them answer that, because I know there are a number of single-line agents for some of the proponents.
Okay. The reason I'm asking that is, as I serve on the board of the Kansas Association of Health Underwriters, which are health and life agents. We may have a sprinkling of people who are dually licensed. So I ran this past the board and talked to some of our members about it. And as you and I have discussed privately, the concern for them is, one, I'm not sure where the department, maybe you could clarify that, that'll be my first question, is coming up with this $5 million in savings when you have about half of the people that are dual agents and about half that are not. So we're adding 6 hours to one side, taking away 6 hours from the other. How does that end up being a $5 million in savings?
Yeah, the $5 million is actually specific to the appointment issue that Sue Ann talked about. Yep.
Okay, that makes sense. And then the next question is, you said that a lot of the questions that have come into the department have been people who are dual licensed and saying, I have 26 hours, but I don't meet 12 here and 12 there. Wouldn't it make sense as far as educating our agents, which is why we have CE to try to keep them current, that it should be 12 and 12?
That's a good question, Senator. I would say that's pretty well known now. I don't know why individuals get the 24 hours stuck in their head and don't distinguish between the lines. But, I mean, we average 10,000 calls, you know, kind of related to this nature. And I think some of it is the complexity of how our licensing system is set up, because our licenses are tied to the lines of authority. So you can end up with different renewal dates. I think that certainly, you know, has a component to it. But, you know, I can't speak to why it's an issue for them. I can just tell you the calls that we receive on our end.
So regarding that, so let's say it's 16. If we're not going to, would we not still get calls, the fact that it's 24, now it's 16, that they would need to have 8 and 8? Or are we doing away with the 8 and 8 and saying you could have 16 hours?
So in the proposal, it's 18, 3 of which would be ethics, and the remainder would be, if you wanted to do, there are certain classes that are specific to one line or the other, and then there's also general insurance that kind of covers, you know, the gambit. So this makes no distinction, and it gives more flexibility for the classes that you can take.
So that was the concern, just sharing that from ours. And if I may, Mr. Chair, I have one more question, and that is, you know, I find, and it's either called NIPR, and most of us, I'm a member of the National Association of Health Underwriters, refer to NIPR, and I heard somebody call it NIPR, right. So whichever term you want to use. I find it very easy to renew my license on there now, and I haven't found the CE, and nor have any of the other agents on the individual. So I guess we would be, I guess my question is, I don't see a driving need. The part that the agencies have talked about and the appointments makes total sense. The changing of the number of hours does not. So thank you for answering my questions.
Sure.
Thank you, Mr. Chair.
Additional comments or questions? Senator Pack.
Mr. Chairman, Director Modisett, you are there. You made a comment. I wrote it down. Quote, "We shouldn't be like everyone else for the sake of being like everyone else." Close quote. And I set that up because I'm going to ask a question here in a little bit. But as far as the bill before us, on page 18, I have a question regarding an applicant whose license has been denied after a hearing must wait 1 year. A licensee whose license has been revoked must wait 5 years. And this is new language. Why the difference between someone who's not licensed but wants to be, or someone that's licensed that wants to get licensed again? Why the 1 versus 5? Why are these
Sure.
the same?
Sure, Senator, I appreciate that question. So there's kind of a two purposes for that. One, the current process and the issue that we run into from the department is that there is no timeline if we deny an applicant for how long they have to wait. And there are times where applicants are denied for a whole host of reasons that I don't want to necessarily get into the details of, but suffice to say, they meet the criteria that we've outlined in other sections of the statute. They're never going to get a license without more timeline in between or showing good behavior, you know, things like that. They get their denial, they turn around and apply the very next day. And so we have to spend staff resources going right back through that same process when the decision doesn't change from, you know, yesterday, today, or tomorrow. The reason for the 5-year is because once a license has been granted, there are a number of constitutional protections that come with that. So the ability to revoke a license requires a much higher threshold from the department to be able to justify taking away that license. And so the distinction is, if we get to the point of revoking that license, the severity of that is different than if we're talking about denying the application on the front end.
Sure, I agree with that. I think that you can deny for the same reasons that you revoke, but that I will leave that alone. On page 19, again, new language. We're looking at page 35. It talks about the commissioner shall assess a penalty of $100, and then in 43, an individual shall provide and pay a reinstatement fee of $100, and then in line 4 on page 20, it talks about shall apply for a license and pay a $100 fee. But then the very last line in that new language says, the commissioner may waive any penalty imposed under this subsection. So we got contradictory language here. It says they shall, but the commissioner might waive. Well, either they shall not or maybe they may. I don't know. I just thought I would point that out and ask if you can help me understand why the shalls, because we're told up here all the time, shall means requirement. It'll happen. And then this commissioner has the authority to waive this. The statute says they shall pay it.
Yeah, so thank you for the question, Senator. I can tell you that the thought process behind this is that there are different circumstances in which an agent may run into this scenario. There may be an event in their life that took place that, you know, took a considerable amount of time. And so the can waive allows us that if there's a reason to believe that they acted in good faith but had something happen in their life that didn't allow them to meet this, then that fee could be waived. If you want to strike the ability for us to get to consider those circumstances, you know, certainly we could. But I mean, that was the intent. Is that there may be, for lack of a better description, a very good, sympathetic situation that would kind of compound an existing problem.
I understand that. I have no problem with the commissioner having the ability to waive. But when it says that they shall do it, and then it says she can let them off the hook, it just looks like inconsistent.
Sure.
Now, Mr. Chairman, I'm going to go down a little bit of a road that's already been gone down. As an agent who's been licensed for a little while, I'm a single-line agent, and the bill would require that single-line agents take additional continuing education hours. Are all single-line agents currently required to take continuing education hours?
If they are, unless they fit a limited line. There are provisions in statute that deal with limited lines, and they're either no CE requirement or there is a limited number of CEs.
Some single-line agents aren't required to take any. Some currently are required to take 12, and you want to move it to 18, but you're not going to require those other single-line agents to start taking any. And now there's a lot of this legislation in 37 I support, and good things for insurance companies. This is great for dual-lined agents. They don't have to take 24. They can drop down to 18. I like that. I'm not a dual licensed agent, but you're doing the socialism thing, taking from those that have and giving to those that have not. And I'm not supportive of that at all. Mr. Chairman, I do have a question for the young lady from, let's see, that would be the CAO and counsel and secretary, a lot of positions that Ms. Schultz has. Thank you, Mr. Director Modisett. I appreciate you answering questions, being willing to stand before the committee. As far as the question for Ms. Schultz, you mentioned talking about the continuing education and how a lot of agents take more than necessary, and I agree with that. I get way more education than I need, but it just doesn't count for my CE. If it's such a great thing, why would you support reducing it from 24 down to 18?
Thank you, Senator. It's a great question. And as you'll see in my written testimony, IMA has actually been a proponent to go to 24 hours. And the reason that we are supportive of the 24 hours is so that we have greater consistency with the other states. While reciprocity, and as a licensed agent, I know you can appreciate what that means, reciprocity enables us to move across state lines so that we can continue to represent our clients who do business across state lines. A concern that we've had as an industry is if NARAB 2 is ever put into place federally, that is going to require 24 hours in order for you to be able to continue to do some of that reciprocal work in other states. The 18-hour CE requirement as set forth in this piece of legislation is a compromise that the Kansas Association of Insurance Agents and the Kansas Insurance Department work together to create, to try to provide a stepping stone so that if there becomes a need to go to 24 hours, that we're already halfway there. And I think, and I appreciate your comments too, because we certainly do support having all of our licensed agents gain as much education as they can. The vast majority of my licensed agents are actually single lines. And so this is going to require an increase in their continuing ed. That is not a problem. Those reputable professional licensed agents like yourself already get far in excess of the CEs required, because that's what it takes to be a professional in our industry today.
I appreciate that answer. And Mr. Chairman, that what she said is exactly what I believe. This is a step. We're working toward 24 hours for single-line agents. And for the persons in the room, I'll just make a comment and then turn the floor back over to you, Mr. Chairman. The persons in the room who have never taken continuing education credits in the state of Kansas, you don't realize that I am a single-line agent. All single-line agents, like myself, life only, that's all I write. I can take property and casualty CEs, which are of no value to my license and no value to me in talking to clients, but they qualify for my CE. And so, again, I support a lot of this legislation. I support dropping down to the 18 hours, great. But if we're going to have a 25% reduction for dual licensed agents, I'd like to see a 25% reduction for single-line licensed agents, Mr. Chairman.
We're getting close on time. Are there any comments or additional questions?
One question from Senator Pittman I forgot to address, so I apologize for that. As it relates to the question about applicant's age, keep in mind that this entire paragraph deals with to deny, suspend, revoke, or refuse. So one example of that would be if we have an applicant who, I mean, let's say they're, my age now, but they did a deed that was punishable when they were 17. There's, it's kind of an evaluation when issuing that license. Has enough time passed to have reason to believe that this individual has, changed for the better.
Senator Gossage.
Lee, if you want to stay up there for 1 second. If it's all right, Mr. Chair, I thought of another question from the question that Mr. Peck had asked, and that is, do we have any difficulty with agents in the state of Kansas with reciprocity getting licensed in other states?
Presently, no. We did. I will tell you that when we worked out the compromise to kind of hit this middle ground, we knew that Missouri was the lowest of when you go to one single unit at 16. We considered going to 16 as Kansans. We like being slightly better than Missouri. This came as a kind of a middle ground. I will tell you that I kind of cavalierly tossed out the idea, could we go to 12 for everybody and eliminate any argument whatsoever to making these changes? And we had a number of carriers who said, hey, we're okay with 18 because we know Missouri's at 16. We feel like that's probably the floor. We don't know that we want to go to 12 because we have concern that other states would really start to look at us now and say, hey, we're not going to let you do business here unless you meet our CE standards, because the vast majority of them do exceed even the 18 that we're proposing.
We don't have a problem with that now.
Currently, no.
Right.
Yep.
I'm multiple licensed in nearly half the states. The other question that I had about that is we have more than doubled the number of ethics. Why was that decided? Because we have one CE ethics now. 3 CE ethics seems excessive.
Thank you for the question, Senator. So if you have 2 licenses and 2 lines of authority, you actually have to have an hour of ethics each. And then the model is 24 hours, 3 of which must be ethics. And to be as candid as possible, when we are losing negotiation point after negotiation point, that was the only piece of the model that was left that we could get everybody on board with. So that's why we were at 3.
Thank you.
Additional comments or questions? Okay, seeing none, we will close the hearing on Senate Bill 37. I'd like to let everyone know that all of today's testimony is loaded on the Insurance Committee page on the Kansas Legislative website, and it's under the early release documents. Okay, I see no other business that needs to come before the committee, so we are adjourned.